All right. Hello, everyone. We're so pleased that you could all join us today. My name is Emily McPhee, and I'm a development associate for Broadband Breakfast. We at Broadband Breakfast have been holding these live online events every Wednesday at noon Eastern time for the past year, and I'm especially excited for this week. We've got a great group of panelists who are here to debate the increasingly controversial Section 230. If you're in our live Zoom audience, we'd like to ask that you keep your cameras and microphones off for the duration of the event. So without further ado, I'd like to introduce our moderator today, Carl Hergendover. Carl is an assistant editor at Communications Daily. He covers tech policy on Capitol Hill and is focused on issues related to Section 230, privacy, and antitrust. He's been covering the tech industry and its regulators at the FTC and Department of Justice for the past 3 years. So Carl, over to you.
Thank you, Emily. I appreciate the invite and the chance to moderate this discussion. We've got 4 Section 230 experts with us today. Neil Freed, he was formerly Chief Communications and Technology Counsel to the House Energy and Commerce Committee and Senior Vice President for Congressional and Regulatory Affairs at the Motion Picture Association. He also helped implement the 1996 Telecommunications Act while at the FCC. In 2020, he launched Digital Frontiers Advocacy, which advises clients on Communications Act and Copyright Act issues. Next, we have Scott Cleland. He's a Christian, conservative, Republican, and president of Precursor, Responsible Internet Consultancy. He served as Deputy U.S. Coordinator for International Communications and Information Policy in the George H.W. Bush administration. Institutional Investor twice ranked him the #1 independent analyst in communications when he was an investment analyst. He has testified before 8 congressional subcommittees 16 times. Next, we have Baron Zoka, president of Tech Freedom. Previously, he served as senior fellow and the director of the Center for Internet Freedom at the Progress and Freedom Foundation. Before joining PFF, he was an associate in the communications practice group at Latham & Watkins LLP, where he advised clients on regulations affecting the internet and telecommunications industries. He also served for the Honorable H. Dale Cook, Senior U.S. District Judge for the Northern District of Oklahoma. Finally, we have Kathy Gellis. She gave up a career as a web developer to become a lawyer with a particular focus on tech policy. She advises clients on platform liability, copyright, trademark, privacy, and cybersecurity. She also frequently writes about these subjects for outlets such as The Daily Beast, Law.com, and TechDirt.com, where she's a regular contributor. Our 4 panelists will be participating in an Oxford-style debate today. The audience is going to be polled at the beginning and the end of the event about the following resolution. Section 230 is harmful and should be abolished or significantly changed. The 4 speakers are going to be divided into 2 sides, an affirmative side and a negative side. Each panelist will be giving an opening statement on the resolution and offered a chance at a rebuttal. A Q&A with the audience and the moderator will follow. Again, here's our resolution. Section 230 is harmful and should be abolished or significantly changed. I believe we're going to begin with our first affirmative speaker, Neil. Neil, the floor is yours.
Thank you, Carl. And let me thank Broadband Breakfast for inviting me to participate today. Personally, I believe that Congress should amend, not revoke, Section 230. Congress was prompted to enact Section 230 in response to a 1995 case, Stratton-Oakmont v. Prodigy. In that case, a New York trial court concluded that the fact that Prodigy moderated some of its content meant it could be held culpable for posts that it didn't moderate, particularly a defamatory or allegedly defamatory post that it had not moderated. And this concerned Congress. Congress wanted platforms to moderate harmful or unwelcome behavior online, but feared that the precedent of Stratton Oakmont would discourage platforms from moderating for fear that they would become culpable for content they didn't moderate. This disincentive is referred to as the moderator's dilemma, that if you moderate a little, you have to moderate everything. And so instead you would moderate nothing. The way Congress addressed this concern was by enacting Section 230. And particularly Section 230C2 avoids the moderator's dilemma. It says that a platform cannot be held culpable for on the basis of the fact that it has moderated content. And with that security, platforms can moderate without worrying about incurring liability. That's helpful, that's useful, that should be preserved. We want that moderator's discretion to create a healthy environment, but to still allow expression, commerce, creativity online. The problem comes in with Section 230C1, right? That was C2. That's essentially the content moderation safe harbor. That's good. Courts, however, have construed C1 as providing a shield, an almost total shield from liability for any third-party content, even if the platform has been negligent, reckless, or knowing in allowing that content and that behavior on its platform. And because of that interpretation, courts have held that they can't even hear often legitimate concerns of victims who believe that a platform has facilitated illegal sale of opioids, dissemination of child sexual abuse materials, involuntary dissemination of intimate videos, terrorism. There's, if there's a harm in the real world, right, we're finding it is happening online. And in the real world, ordinarily, we would require anyone hosting a platform, anyone hosting a venue, anyone operating a store to act reasonably to make sure that consumers and the public are not harmed in the process of using their facilities or services. And unfortunately, because of the way courts have applied Section 230, particularly C1, that's not happening. The way to solve this, I believe, is for Congress to amend Section 230 to require platforms to take reasonable steps to curb unlawful behavior. And here I'm focusing on behavior, right? The real thing we need to worry about is illegal conduct. People are being harmed online. The internet is a wonderful place, but it's part of the real world now. And just like there are harms in the real world, there are harms online. And every non-regulated business in the United States is subject to some accountability. They can be held culpable if they are acting negligently, recklessly, or knowingly in facilitating harm. And at this point, I see very little reason to treat the platforms differently. Applying the reasonableness standard should not be confused with requiring absolute liability for platforms. If they take reasonable steps, they still get the benefit of the shield. They can't be held liable for third-party conduct. And remember, if we save C2, we still have the content moderation safe harbor. So expression can flourish, and the reasonableness standard is itself quite flexible. It takes into account the foreseeability of a harm, the level of the harm, the resources available to the platform. So small platforms and large platforms will not be treated the same. The courts have been applying a reasonableness standard for more than 100 years. There's ample precedent on how to apply it, and there would have been even more precedent to apply it, but for Section 230. For the past 25 years, we haven't been able to develop online-specific precedent on what is reasonable. Maybe many platforms are acting reasonably. Certainly not every platform is acting reasonably, and certainly not acting reasonably all the time. We should be able to ask that question. Has a platform acted reasonably? We can't today. People are being denied access to the courthouse steps because of it. Certainly there are going to be unreasonable cases, and those cases will be tossed out. In fact, the Internet Association has done a study, and more than half of quote unquote Section 230 cases are actually dismissed on non-Section 230 grounds. Those cases will still be dismissed. But by applying a reasonableness standard, we don't require platforms to be perfect, but we can hold them accountable when they act irresponsibly. And that I think we need, again, to address illicit activity, illicit behavior happening online. There's, of course, a separate set of issues about lawful speech. There are concerns about misinformation, about bias and hate speech. That's more challenging to address because even when some of that speech, yes?
We've reached 6 minutes.
Okay. For speech issues, because it's often lawful, even if not always desirable, there are First Amendment concerns. And I think the best approach there is for Congress to adopt transparency requirements that ask platforms to explain what their policy is about what they'll take up and what they'll leave down, and to hold them accountable to honoring their policy. If they don't honor their policy, that could be a deceptive trade practice. But again, they wouldn't lose a case unless someone could argue that they had a valid legal claim of misconduct. So those would be my recommendations. Thank you.
Thank you, Neil. And now we're going to turn to Barron, who will give his side's opening statement.
Actually, it'll be me.
Oh, Kathy. Okay, yeah. We're going to turn to Kathy.
Okay. Thank you for having me here to speak about Section 230, which is one of my favorite subjects. I'm an ardent advocate of it. In my opening, I want to take on 3 things as a roadmap. First of all, challenging the basic premise that Section 230 is harmful. Secondly, to go into the basic mechanics of how it works. And thirdly, to take on some of the various reform proposals to quote unquote amend it, which I think would have the result of not amending it, but more obliterating it. And I'll go into some detail why. And then in Barron's statement, he'll go into more technical detail underlying a lot of these arguments. So to get back to challenging the premise, this idea that Section 230 is harmful, that needs some scrutiny. One of the things that's happening is that Section 230 is getting blamed because it's an effective law and it's enabling the internet to exist. And bad people sometimes use the internet to say and do bad things. And let me not be too flippant with it. I'm using shorthand just so we can kind of get a grip of the arguments, but some of these things are truly and utterly terrible, and I don't mean to minimize them. But because it's getting all this, because it's getting blamed because it's really the only game in town, it's the only really effective policy we have interacting with the internet space. And because that's happening, it's doing all the heavy lifting. And what it really needs is some complements, some targeted things that deal with the actual negative externalities, the bad things that are happening. It needs help. It doesn't need destruction. It needs friends. And what we should really be doing instead is looking for how we can narrowly tailor actual solutions to the specific problems without taking away something that's important, effective, and needed. Another point to raise, and I believe Barron will go into it more, is a lot of what we're unhappy about, a lot of the problems. This is really a byproduct of the First Amendment, not Section 230. So changing Section 230 wouldn't actually do anything to address a lot of the things that are being complained about. And then finally, a really important point is, do we even all agree on what is bad? No, we don't. Let's look, for example, at what, how incredibly polarized the country is politically right now with what red states want and what blue states want. There's a huge gap between them. So how could we all agree what good or bad is? The reason we have the First Amendment is because nobody gets to decide, because we could never decide effectively. And that extends to Section 230 and why it's so important, because it means we don't give somebody the power to make those decisions. Now I want to get to the meat of this. Section 230 is good. Overall, what it does is enable the most beneficial content online and keep the least amount of detrimental content online. It's not perfect, but it is as close as we can get to either ideal, to the extent that we'll ever have any consensus around what these things look like. And if we got rid of or significantly changed Section 230, neither of those things would happen. It would be worse on both fronts. There would be less good content and fewer services and fewer service providers offering the availability for online interactions. And we wouldn't have any real robust mechanisms to get rid of the deleterious content, the stuff that hurts us. We'd have a lot less ability to get rid of the stuff that we might all agree really needs to go away. Now, one other thing is that Section 230 does not mean that nobody is responsible for what is wrong on the internet. It very clearly says, hold the person responsible, the party responsible for whoever actually imbued the content with whatever is wrong with it. It's just not the helpers, not the services that helped it get expressed. because they're busy helping an awful lot of content, not just this, get expressed. And if we impinge on their ability to do so, we'll lose a lot of the stuff we really want to have. So let's talk about why. So we want the most good stuff online and the least bad. And so for that, one of the things that's really interesting about Section 230 is how it works. It's not a punitive law. It's not a thou shalt not law. It's a, you know what, this is hard. And Congress is saying, like, this is hard and we really want help. So it aligns the incentives to make the service providers partners with Congress to do the best it can to keep the most good stuff up and to take the most bad stuff down. And it does it by making it safe for them to do the best they can on either front. If they had to fear liability, then they would have hesitancy to, oh my gosh, can we leave this content up? I don't know, we better take it down, even if it turned out it was totally fine and we'd be better off having it. Section 230 immunity means that they can say, you know what, we can take a chance on it because we'll be okay. And it also means they can take a chance on taking stuff down if they feel they need to, because it's harmful information, it's harming their community. It means that platforms are safe to do that as well. And this two-prong approach of getting the platforms on side with Congress to say, we want the best ecosystem we can is really important. We'll talk more. I mean, the problem is if they weren't legally safe, every decision they made would be incredibly expensive and they would have to defend every decision. And this is not something to sneeze at. A motion to dismiss is thousands and thousands of dollars. And if you think about how much volume of user content they're administering it, they wouldn't be able to do it. Another important point is it's not just big tech that this affects, this protects everyone. This is big companies, this is small companies. If we want more competition with the big companies, they need platform protection because when they don't have it, they get obliterated. And then we have fewer of the big companies where we might be unhappy with them and wish we had more games in town. It affects individuals, it affects small services, it affects online publications that take user comments, it affects Wikipedia, nonprofits, individual entities, individual retweeters. We mess with this law at our peril. It affects a lot more than just the people that we might be a little unhappy with right now.
Kathy, right on time.
Yeah.
Now we're going to turn to Scott.
Scott, I think
let me keep my full time, if I may. I thank you for the opportunity to make the case for repeal. I am not a lawyer. I'm a policy analyst for the last 28 years. And so I will have a different view than the lawyers would. But I think that's helpful. Let me simplify this. Section 230 is the only internet law. It applies universally to everything. It affects everything. It's less than 1,000 words long. Repeal would be 700 words, but it is remarkable that that short and that small a universal law isn't getting more pushback for repeal. Repeal nullifies existing law. It's the most simple to understand legislation possible. It's a legal off switch. At the most basic level, as a policy analyst, the two things that the Section 230 does. The most important thing that most people don't talk, well, they don't talk about it because they say the 26 most important words of the internet that made the internet. I disagree. It was 6 words, unfettered by federal and state regulation. That was the thing that did it. That was a policy. It said it. That's what characterized the internet. The second thing. So the policy, and the second thing, I'll let the Internet Association explain. It ensures platforms can provide a place for users to collaborate without being held liable or responsible for censoring user content. So whether or not that material is constitutionally protected. I think that over time, we're going to find that Section 230 is much more constitutionally suspect and at risk there. But I'll make a point is the internet does not need 230. It's an autonomous, automated, self-executing P2P network of networks. Internet platforms want Section 230 so they can be unaccountable and have no responsibility to protect others. Repeal would not change how the internet or the internet or how it operates. It only would change the government policy and law for interactive computer services, and it would Today it makes them largely unaccountable with no responsibility to protect others. Repeal would do the opposite, make them accountable and responsible and restore a duty of care. So what we're talking about is really what is the legal default on this ecosystem for the US? Is the legal default lawlessness, or what they call the Wild West internet, or lawful? So like where I agree with Neil is the problem is unlawful, but the policy basically says it was unlawful, and it was allowed to run that way for 25 years with a lot of damage. So why do I say repeal versus reform? Repeal would serve America and Americans much better than reforms, because reforms are all perpetuating the lawless US internet policy and law, and big tech will remain largely unaccountable, and people will continue to have no protections online because of 230. Repeal would be a major policy change. Reform is incrementalism, if it can get done, that would largely preserve the lawless status quo. Repeal would be comprehensive and constitutional. There's no problem with Congress undoing a law. Every repeal, all the language will be looked at and is potentially constitutionally challenged. And also a repeal would be piecemeal and not be a universal solution. So repeal is also inevitable. It's based on an unreasonable government-imposed lawlessness, which inflicts severe damage to America's constitutional liberties, national security, economic prosperity, and Judeo-Christian values. Repeal say, oh, will there be unintended consequences? It would have two very clear intended consequences. Checking unchecked big tech, essentially creating accountability online for internet computer services. And it would begin protecting unprotected people online, because it would restore a duty of care and restore people's day in court. So let's put this in context. People are just talking about how this law is so wonderful, only does good, and it should be around for perpetuity. Let's remember, America's one internet law is based on what Congress knew about the nascent 96 internet, which had bulletin board functionality, dial-up speed. One US senator used it, and the several million Americans that did use it did so for an average of 30 minutes a month. Section 230's lawless internet policy essentially degoverned and conformed America's constitutional system to the utopian and anarchic internet policy experiment of an amoral, borderless, permissionless digital commons open to everything and everyone with no central authority. Today, that lawless policy applies by default to everything everyone does online, everywhere in the work for the U.S. for work, life, and play. So, without any online and it applies without any online First Amendment rights, recourse, or redress forever until Section 230 is repealed or overturned by the Supreme Court. Summary: nullifying Section 230 via repeal or constitutional challenge, which I think there will be coming up, would restore Americans' liberty, constitutional rights, rule of law, redress, right versus wrong, free market capitalism, without new regulation, simply by restoring rule of law.
Scott,
Section 230.
We've reached time.
Whoops. Okay, let me say it's a one-sided, one-way loophole that only benefits internet companies at everyone else's expense. And it's a simple binary choice. Do American voters want to unchecked big tech checked, or the unprotected protected or not? Thank you.
Thank you, Scott. And now we'll have Barron wrap up opening statements.
I'm not a 230 absolutist. I'm open to amendment. For example, we could be having a conversation about requiring takedown of content that has been adjudged by a court to be unlawful. But that's not what we're talking about today. That's not the proposition before us. What you have heard is a misrepresentation of Section 230. The internet is not lawless. Section 230 has always excluded intellectual property law and, importantly, criminal liability, such as for CSAM. I'm open to having new federal criminal laws. And in fact, Tech Freedom supported and helped draft the provisions in FOSTA that strengthen criminal penalties for sex trafficking. Moreover, Section 230 is never applied to content that a site is responsible, even in part, for developing. So for example, we have been able to bring law enforcement actions against sites like roommates.com and against Facebook for enabling discrimination in housing. But more generally, I actually agree with Neil. There is far too much misinformation, hate speech, and abuse online. But as Kathy noted, there's very little the government can actually do about such speech because of the First Amendment. This is not Europe. We can't directly ban hate speech. Section 230 aims to do the next best thing, which is to remove disincentives to moderate content. Now, what Neil is proposing, whether he realizes it or not, would actually discourage moderation of awful content online, which is why Neil finds himself on the same side today as Scott, whose goal, his open goal, is to force websites to host the most appalling content imaginable. He invokes Judeo-Christian values, but what he's really talking about is that websites would have a duty to carry, for example, openly Nazi speech. If you listen carefully to their arguments, you'll see that they're actually pulling in opposite directions, which illustrates the dangers of amending Section 230. There is an unfortunate coalition of people who are attacking the law for very different reasons, but they would have the same essential effect, which is to make it more difficult for websites to refuse to carry awful content. But let's start with why we have Section 230, why we need it, and what it does. There are really two functions. First, Section 230 limits liability for third-party content. Here, we needed 230 to change the common law because the common law produced a framework that was unworkable in the internet. It was unworkable at the scale of content online. It created two perverse incentives. The first one is one that Neil has talked about. It was not to moderate content because under traditional publisher liability, if you have editorial control, you will be held liable as a publisher. Stratton Oakmont reached that conclusion. But what is often missed in this conversation is that it wasn't just Stratton Oakmont. That is the baseline law. The only reason that CompuServe avoided liability in the 1991 case of Cubby is that the plaintiff had not alleged facts that would have proved editorial control. So Neil is really missing the second half of what he has referred to as the moderator's dilemma, which is the other part of the common law, as noted in Cubby, was that if you have knowledge or actual knowledge, you're liable as a distributor. And again, that was not pled in Cubby. But if CompuServe had, for example, taken complaints from users or had monitored content on its network, it would have been held liable. Congress understood that that was a huge problem. That would discourage websites from monitoring awful communications and trying to protect users and taking complaints. So 230 overruled the common law in both respects, and we needed it to do so. And if we hadn't, we would have wound up in a situation such as Canada has today, where websites are only protected from liability for third-party content under the innocent dissemination defense if they are extremely passive. Well, Congress understood that would be a bad result, and that's not what we wanted. So Section 230 prevents that. That's the first function. The second function is protecting content moderation, the refusal to carry content. Here, 230 does not change the common law. It simply provides a civil procedure shortcut to the result that the First Amendment would get us anyway. And it does this not just through Section C2, as Neil has referred to, but also through Section C1. In fact, almost all content moderation cases have been resolved under C1. C1 says you may not be treated as a publisher of information provided by others. And that has been held consistently to mean that you may not be held liable for any of the decisions that publishers make, which includes the decision to refuse to publish content and the decision to withdraw content. Now, Neil says it's no big deal if we get rid of C1 because we'll still have C2. This misunderstands that these two provisions work in fundamentally different ways. C2 is a very difficult provision to use on a motion to dismiss. And what that means is that if you are arguing that you're not liable under C2, you will probably be subjected to discovery. You will have to receive interrogatories from the other side. You will have to establish your good faith, and only then, perhaps at a motion to dismiss, sometimes at a motion, at a motion for summary judgment, sometimes at a motion to dismiss, will you be able to escape liability. That's not enough. The whole point here at the end of the day is that Section 230 protects websites from what has been called death by 10,000 duck bites. That is to say that the American legal system is uniquely stacked towards offense. This country has 15 times more lawyers per capita than Canada does. And one of the reasons for that is that it's very easy and cheap to bring a lawsuit in this country. And if you lose, you don't lose anything. And the other side has to pay 10 to 100 times more to defend themselves, depending on the circumstances. Whereas in Commonwealth countries, loser pays, at least in part. So we live in fundamentally different worlds. We need Section 230 to do this. And at the end of the day, as I will explain in my follow-up remarks, all of the arguments that one hears from the other side about how websites would not have a First Amendment right to remove content, all of those arguments fail. They have the same right as newspapers do to remove content. They are not public fora, and they are not common carriers. And I will stop there.
All right, thank you, Baron. Now we're going to move to rounds of 4-minute rebuttals. I believe we'll start with Neil and Scott's side.
Is it me or Scott?
Scott, go ahead.
And it's 4 minutes each, correct?
4
Yes.
minutes.
I'll go ahead and start. So it seems that much of the debate is between my interpretation and Baron's interpretation of 230. As you might imagine, I disagree with Baron's description. Under common law, every business has a legal obligation to take reasonable steps to moderate its business. The goal was to eliminate the disincentive created by Stratton Oakmont. That's C2, that works. But the courts have gone too far because, as Baron points out, no one relies on C2. They rely on C1. And C1 says you don't have to do any moderating. You can know that there is illegal activity and do nothing about it. And every other business in America has an obligation, if they're aware of some illegal activity by one of their users, to take steps. So because C1 has been interpreted this way, platforms have no legal incentive to moderate content. There are other incentives, but there is no legal incentive. And if we didn't need legal incentives, we wouldn't need law. So that's the problem. I agree with Baron, we want C2. C2, if actually used, would ensure that platforms can carry what they want, they can take down without fear of liability what they need to take down. That's the solution. And the reasonableness standard, again, doesn't mean that they're liable for what someone else does as long as they do something reasonable. If they do something reasonable, they still have their shield. In addition to more than half the cases that are dismissed, not because of application of Section 230, but because there's been no lawful state, no legal recognizable claim. Look, the internet is a wonderful thing, but George Carlin used to say, people are great, crowds not so much. And that's just a funnier way of saying we need the rule of law. And all of our economic activity is moving to the internet. As Rick Lane, who many of you know, often says, e-commerce is commerce. And we can't have all of our commerce move online, but not have the rule of law move online as well. And that's all we're doing, is making sure that platforms have to be reasonable in their moderation, not perfect, but be reasonable. And if they're not being reasonable, someone should be able to take them to court and have their case heard. They may still lose their case, but courts can't even hear that. Victims can't even have their concerns heard. And that's why we have victims' rights groups and online safety groups saying, we have to do better. We have to let victims of third-party conduct that platforms are irresponsible about have some venue. Thank you.
Thank you, Neil. Kathy and Baron, who wants the first round of rebuttal?
I think I'm going first. Well, first of all, Neil misstates the common law. Multiple courts have held that websites do not, in fact, have a duty to moderate harmful content on their services. But the real issue here is that Section 230 was created not merely as a shield from liability, but as protection from suit. We cannot have an honest conversation about this topic unless we understand what makes the internet different. We have content that exists at a scale that is unfathomable in any other context. When you multiply that times the expense of litigation in America's uniquely litigious system, you have a huge disincentive to do anything that could get you sued, including moderating content, merely because it is so incredibly easy to file suit. So Section 230 works to the extent it works today by providing protection from suit, not merely protection from liability. Neil presents the idea that we should have a reasonableness requirement as some moderate change, but in fact, it would fundamentally change the statute, because while the statute still could offer ultimately protection from liability, it would be impossible for most sites to actually bear the expense of litigating to get there at the volume of litigation that would be incentivized in that world. Right, what we're talking about here is whether you have to go through discovery, whether you have to fight all the way through a motion for summary judgment, These things can cost hundreds of thousands of dollars. And in litigation in general, more than half of the cost of litigation is incurred at the discovery phase. Now, he presents reasonableness as a mild proposal. Who could possibly argue with that? Well, as any lawyer knows, the word reasonable is literally, without exaggeration, the most litigated word in the English language. What Neil is proposing is that these lawsuits that must be filed in his world, that would be allowed to proceed past a motion to dismiss, could not be resolved until the courts work through the allegations about what is reasonable and what is not. And as we lawyers know, we have a very low bar for pleading claims in this country. Now, I will just close in the time I have left by noting once again that Neil and Scott actually are on opposite sides here. Neil wants more content moderation and Scott wants less. Now, Neil's way of trying to bridge the divide between those is to say he wants to have mandatory transparency. What could be wrong with that? Well, that too is unconstitutional. You could no more compel, quote, detailed disclosure, unquote, from a website as to why it refuses to carry content than you could compel the same thing from a newspaper or a book publisher as to why they decide not to carry letters to the editor or to publish certain books. Nor can consumer protection law police claims that a website has supposedly promised neutrality or fairness or whatever and refused to deliver. Those claims are what is called puffery in standard advertising law. They are not capable of objective verification. And fundamentally, what we are talking about across the board here is non-commercial speech. It's not how many calories are in your soda. It is, how does the website define hate speech? What constitutes misinformation? These are editorial judgments about matters of profound public concern that the courts will never allow the government to intrude upon. And in fact, if you look at, for example, the McManus case in the Fourth Circuit, the case revolves around the court saying that we will not permit the government to entangle itself in these sorts of line drawing exercises. These are as reserved to the judgment of private media today online as they would be in any other context. And the only exception to that is broadcasting, because broadcasters are licensed by the government. They're a clear state action. So what he is proposing is unconstitutional. And at the end of the day, what Scott wants, which is a must-carry mandate to carry speech, however awful, will never be upheld in court.
Thank you, Baron. Scott, your chance for rebuttal.
What should be clear here is that, you know, when you talk about 230 and defending it, that law is all to the benefit of businesses, of essentially tech corporations, internet computer services. It is one way. It doesn't care about others, whether of any type. It is all about how can they maximally protect and lower their legal fees. And it doesn't matter if people are victims of crime or of other harms. People just don't matter at all in a 230 world. They're not protected. They are discarded. And so my whole point on this is that why? Everybody else except internet interactive computer services, everyone else has to follow the law, has a duty of care, has to respect others and not harm them. Essentially, when we talk about lawless, when you are unfettered by federal and state regulation, unfettered means basically there's nothing that that can hold you back, and it basically is conferred impunity that companies are allowed to operate with impunity, using the Department of Justice's words in sending it to Congress and asking about it. But what is so offensive here, and so the callousness that there should be nothing in 230 about protecting people from harms. I mean, cybercrime is totally out of control. Ransomware, totally out of control. Cyber espionage from China. They have 5,000 cases at the FBI, they were saying. I mean, the 230 people live in a bubble and say, la-di-da-di-da, everything is good from our perspective. But if you look at what is happening out in the world, and that's what I do. I mean, national security and public safety are ravaged. Why? Essentially, there's a policy in the U.S. that every department and every agency in the government knows, which basically means we're not supposed to do stuff online. So as a nation, we are discouraging anything that that rational people would do. And it's a completely irrational policy. I do ask all three of the others of saying, if you're just caring about, you know, the legal language, would you support excising that U.S. policy of unfettered by federal and state regulation? I'd be curious to see whether you think that's important or not. But I certainly know the companies know that that's the money provision in here, not the moderation. And you know, so what you have right now in the United States, and just ask any cybersecurity person that really knows their stuff, there is no market incentive, there is no duty or any requirement from the government that they need to make anything safe or secure. So when you're talking anything that touches the internet, none of it can be made safe or secure because of the policy in Section 230. We have a government that has de-governed itself. It is a war where basically we are adopting the internet lawlessness in place of constitutional rule of law, rights, redress, and the First Amendment, the Fourth Amendment, all of that. And what I'm saying is people should look at 230 from the voters' view. And if the voters have a chance to look and say, I'm getting nothing but harm from out of this. This is, you know, they may say, oh, I get to see more, you know, comments or other things. What they're caring about is am I going to get harmed, or am I going to get censored or canceled? And they have impunity. Time's up. Thank you.
Thank you. That wraps up our debate portion.
Oh, me.
Kathy still has to.
No, we've got one more rebuttal. Kathy.
Okay. All right. One quick point I want to amplify with what Baron said, and I didn't go into the specifics of why specific reform proposals. I said that basically might as well repeal Section 230. If you have to litigate whether Section 230 applies to you, you might as well not have it at all, because there's your litigation budget. And if you're doing it on a case-by-case basis, it's game over. But I want to get to sort of these general comments that are coming up now, that come up in a lot of these debates, which Scott was talking about. It's not about people. It's about everyone. It's about an ecosystem. And the problem that we're having here is that the internet is so big, it's hard to keep in our heads everything that's going on in it. It's much easier to focus on things that are bad, things that are problems, but that means that we often miss or take for granted all the wonderful things that are actually happening. Even without us paying attention to them, they're happening seamlessly, and we'll miss them when they're gone. Furthermore, it means that if the internet is so big that even if only a tiny percentage of things are going wrong on it, that adds up to a lot of things, and sometimes even terrible things, and it can seem overwhelming. So it can make sense to have the reflex to say something must be done. But that doesn't mean we change the bit that's working. This is killing the golden goose, and this would not be a good idea. Because one of the reasons that our democracy has free speech as a value, and democracies depend on it, is because ultimately it's a matter of control and power. And we have rules about what speech is okay. And if we have rules about what speech is okay and what's not okay, then we have questions of who will decide which, and who will have the power to enforce it. And what happens to the people who have things to say that the people in power who make the rules don't want them to say? This is a mess. This is a mess. This is why we want to make sure that we have the widest expansion of free speech values. But the trick with 230 is at some point it's nice to say, but the rubber hits the road. The rubber hits the road of what is it going to make it so that effectively our free speech values can actually be meaningful online. And if we have the platforms getting run over, obliterated by litigation unnecessarily that they would ultimately end up being victorious on, we're not going to be able to facilitate it. Now, some people who worry about the deplatforming and things like that talk about, well, what about my rights of free speech, and I should be able to stay up. And free speech as a value is certainly something we should encourage. Similarly, some people also point out that that means that you have to be able to moderate your communities in order to make sure you don't drive voices off of communities. This is not a clear answer of what road we want to hoe. But it does mean that we need to keep our eye on the ball of the ecosystem to make sure that the ecosystem is equipped and doesn't have artificial barriers that are going to warp the ability to get the most good stuff up and the least bad stuff, and to figure it out on a consensus basis as best as we all can. And it is not about big tech. It is not about Facebook. It is about every platform of every size and every internet speaker everywhere, where if you don't like what Facebook has done to you, that's okay, because we can get another Facebook, because Facebook doesn't have artificial barriers that are making it legally impossible and economically impossible to actually exist and offer their services. We need to make it possible to get the most voices online and have the most services online available to facilitate it, because when it comes to internet speech, we need help and helpers, and we absolutely must make sure that the helpers are able to offer that help and be helpful, or else that speech won't be able to happen, and that will be a loss for all of us.
Kathy, thank you. And that wraps up our debate portion of the event. If anybody in the audience has any questions, feel free to type them into the chat. I'm going to ask the panel the first question. Wanted to ask about President Biden recently revoking former President Trump's executive order on Section 230. Trump was seeking an FCC rulemaking to clarify its interpretation of liability protections under Section 230. Does anybody have any thoughts on Biden's decision? Does the FCC have any role in this debate?
No. One thing that came up when we were talking about the regulation, because people are like, well, if you can regulate, if the FCC can regulate over the air speech, why can't they do the internet? There is an open argument about how constitutional it actually is to do the open air regulation, but the justification has generally been that there's scarcity. There's only so much bandwidth in the air, and it's public, so therefore the government has a role to play in regulating it and make sure that there's equal access and things like that. That doesn't apply to the internet. We don't have scarcity, certainly not at the edge, in any way, shape, or form that analogizes to what happens with the FCC. It was the Trump executive order was helping itself to some jurisdictional power that isn't necessarily statutorily based or constitutionally permissible, but that's the big analog. With the internet, you can keep getting more. And as long as you can keep getting more, there's no place for the government regulation on that basis. You don't have the scarcity issue.
I'll add a couple of things. We shouldn't spend too much time on this because the current FCC has indicated they don't have any intention of moving forward, and even the previous one did. But we need to separate two issues. One issue is, does the FCC have authority to construe Section 230? And it does. That's different from whether one thinks that what President Trump was proposing is good. We shouldn't confuse the two. And interpreting Section 230 is not regulating the internet. It's simply deciding what is the scope of a safe harbor that's within the FCC's jurisdiction. And you'll note that no one at the FCC has said the FCC doesn't have the jurisdiction. They've just decided not to use it and have not expressed support for what President Trump was supporting. So I think we can move past the executive order, and we can even for the moment move past whether the FCC is going to move forward, because this FCC won't. But it doesn't mean the FCC can't.
And if I could add, the FCC, the executive order was addressing a very real problem with Section 230, which it gives impunity to knock down the free speech of people that they don't agree with. And so you have Christians and conservatives and people on the right that, the left used to believe in tolerance and in promoting free speech. But now, if it is not what they believe it should be, they think it should be canceled or censored. And so I know, and then the media will say, oh, no one has ever documented or said that, that there's bias online. I mean, it's just amazing how, literally half of the country knows something that they're being shut down and censored and canceled. And they know Section 230, essentially, Section 230 should really be called speech regulation, not content moderation, because what has happened for 25 years is the courts have been asleep at the switch. They basically, it says, whether or not material is constitutionally protected. Essentially, the government has delegated to interactive computer services to censor. And I didn't know that the US government could delegate an outsider to do what they unconstitutionally cannot do themselves.
So
Tell
here
me,
we
you know,
have
what's
the
going on
two
here?
here we have the two big lies in this debate rolled into one. Lie number one is that Section 230 is what is responsible for what Scott calls censorship. In fact, it's the First Amendment. This is the way in which the executive order was most legally absurd. It misrepresents completely what the Supreme Court said in the Unpacking case in 2017. Yes, Justice Kennedy referred to the internet as the modern town square, but he did so in the context of a case about a state law that restricted access to use the internet. That case was cited by the executive order to suggest that the government somehow has the right to regulate internet services as public for. That's not what the court said. That's simply false. It's not Section 230 that enables content moderation. It is the First Amendment itself, as I have explained. The arguments that have been made for why websites do not have the same First Amendment rights as other media are frankly laughable. They're generally made by non-lawyers, don't know what they're talking about, and then someone like Justice Thomas, who decides to freewheel an argument without being briefed on it. To just cite the same law professor who wrote the Trump administration's executive order. Right? His arguments, I refer you to our lawfare piece to refute those arguments. But that is lie number one. If you repealed Section 230 today, would not change the underlying First Amendment rule that websites get to decide what speech they will not be associated with. And lie number two is that Scott says, oh, well, almost half of Americans believe that they are being censored. Yes, well, almost half of Americans also believe that the last election was stolen because they've been propagandized by the very media ecosystem that Scott is defending. That doesn't tell us anything about what's actually happening in the real world. And if there were a pattern of discrimination that could be proven as distinct from different behavior on both sides, you would, for example, have seen the Trump administration deliver to the Federal Trade Commission what it promised to do. It said it was going to produce a study, a database of complaints and so on. The Federal Trade Commission never got that. There is no actual evidence of systemic bias. The one and only study that is ever cited is Richard Hanania's study in 2017 of what happened in the 2016 election, purporting to show that Twitter was 21 times more biased against Trump supporters than Clinton supporters. And that claim has been repeated endlessly, including in august publications like the Wall Street Journal. But when one actually looks at the database that Richard Hanania was using, one sees that the people that he considered to be conservatives were not people who were removed from social media for talking about tax policy or foreign policy or whatever. They were David Duke, Richard Spencer, Milo Yiannopoulos, the American Nazi Party, Jared Taylor, the leading white supremacist, American Renaissance publication, and a variety of other overt neo-Nazis and actual racists. These are the people that Scott is defending. These are the people that Scott wants to force websites to carry. That's what this debate is primarily about.
And Baron, let me get in on that, because that is just
Scott, do you mind making it brief just so we can get to one audience question?
Yeah, I think that would be interesting. I'd like to, Barron's Tech Freedom 2 days ago, basically, this is quoting his counsel. He said, ultimately, and this was slamming the Florida DeSantis law, and he said, ultimately, the defects in this law show why no social media speech regulation can pass constitutional muster. Well, I'll tell you, 230 is speech regulation. So, Barron,
No,
you're making my case
Scott. No,
that
it's not.
230
It is not. I've already explained it's not
constitutionally challenged.
Sorry, you're just wrong. It is a civil procedure change that allows websites to ensure they can dismiss a lawsuit against them when they are sued. In that respect, it is exactly like anti-SLAPP legislation, which says that when you are sued for defaming a public figure or speaking about a matter of public concern, you don't have to slog through constitutional litigation. You have a statutory right to get the lawsuit dismissed at a motion to dismiss. Section 230, with respect to content moderation, fulfills exactly the same function as does SLAPP legislation. It's not a regulation on speech.
The one difference is it eliminates a duty of care that would otherwise apply. You're correct, Baron. There's no duty of care for platforms, but the courts have been clear, but for 230, you could bring a negligent suit for the way you treat third-party conduct. The Lemon v. Snap case just made that point. Yes, the platform can be held culpable for negligence of its own behavior, but it can't be held culpable for negligence in the way it treats third-party content or third-party behavior. Every other business in America can be held culpable if it is negligent with respect to the way others use its products. Or
That's actually not true. I refer you to Maynard versus Snapchat, which I put into the chat. The court very clearly said that businesses do not have a general duty to police against misuse of their products by third parties.
Yeah, this is they didn't sue the, I think Barron has the better half of the argument there. And I know that the Lemon versus Snap decision came out. I'm highly critical of it. And it's actually inconsistent with some other decisions that went in, mostly because I think, and relating to a question in the chat, these are speech issues. These are platforms facilitating speech. These are not like other products. This is not, and I find it very interesting. They didn't sue the car manufacturer. They didn't sue the car manufacturer who let the kids go too fast. They sued the platform that let the kids document how fast they were going. So they're putting liability on a platform that enabled people to say something. That's why I think it's out of step with what 230 says. And I think it's out of step with what Section 230 should say, because the consequence of this is that, can a platform exist to enable people to say something if the thing they're going to say has a harmful quality to it? It's a problem if they can't, because it doesn't just take away Snap. It doesn't just focus on, well, Snap had a bad design here. It takes away Twitter, because we know that people sit there with the Twitter box and enter their tweets, and some of them are quite harmful. So did Twitter negligently design its box that it's not screening out stupid things that people want to tweet? This case eats the whole, and I think a way that's inconsistent with the statute and inconsistent with good public policy, including, as the important thing to remember is, this is speech. This is not like any other sector. And the consequence when we pressure the censor, when we pressure the sector with all this litigation costs and litigation risk, is that the speech will disappear. And I don't think we want that. We really need to hold out for trying to get the most good online and the least bad.
We have to distinguish speech from conduct, right? So a nightclub that ignores the trafficking of drugs on its dance floor can be sued for negligence. A platform that ignores the sale of drugs in its platform cannot, because of Section 230. Let's focus on the conduct. Let's focus on negligence. 230 creates a negligence shield that was not what Congress intended. That's the problem. It's the negligent facilitation of illegal activity that every other business has to fight, but the platforms don't.
But not under federal criminal law. So if you want to deal with that problem, pass a new federal criminal law.
Yeah, but
Also,
Yeah, well,
Thank you, everyone. Let's move on to another topic. I got one question from Neil Fairbrother. This one's for Neil and Scott. What you asked for in terms of duty of care and transparency sounds a lot like the UK's online safety bill. Will this bill have an impact on social media companies? We've got about 2 minutes left.
So on the transparency, I'm not saying we need to force platforms to do something they wouldn't otherwise do. But if you look at Zotterer, you look at Turner, the government can require a platform to reveal non-controversial information about the service it offers. So if a platform has a policy, Congress can require to say what that policy is and hold them to it. Transparency would be good. It would allow competition, would allow people understand what's happening to them. Duty of care would just make sure that, just like any other business, if they act negligently, they can be held responsible.
Neil misstates the law here. What Turner actually said is that companies that operate as conduits that have a long history of carrying the speech of others, in that case, carrying broadcast channels, could be compelled to do so, because no one would ever associate the carrying of those channels with their editorial judgments. It is worth noting that the cable companies in Turner never objected to the content they were being asked to carry. They merely wanted to control all of their limited capacity to carry channels and to sell them to the highest bidder. That is fundamentally different from this case. This case, what we're talking about now is whether websites can be compelled to carry, for example, Nazi speech.
I'm not advancing compelling carriage. I'm saying, if you have a policy, tell people what it is. And if you don't follow your own policy, the FTC may have something to say to you.
That's never going to happen. The Federal Trade Commission has never in its existence ever tried to police non-commercial speech claims about the nature of line drawing, about hate speech, misinformation, and so on.
and the reality is that people will, if they do it in a way where they said they would do it one way and then they did it another one, that's where the market comes in. That you talked about, that we had a lot, you were lamenting the lack of legal incentives, but basically what these platforms have are market incentives. They don't want to lose their users. And if their users all get mad at them, they'll go somewhere else. And if we're worried they don't have somewhere else to go, then the last thing we should be doing is taking away Section 230, which enables a somewhere else to go to actually exist in the first place.
But everyone else who has
We've reached time, so I've got to cut it off, unfortunately.
All right.
Sorry, it's 1 o'clock. I'm going to turn it back to Emily, and we're going to return to the closing poll. Thank you, everybody, for some lively discussion.
All right, I just launched the poll, so for all of our participants, you can vote, and we can see if we've altered anyone's opinion on Section 230 in the past hour. While folks are voting, I just want to remind everyone that we hold these weekly Broadband Breakfast live online events once a week, and we'd love to have you tune in the future. We had a before poll where the majority of respondents said that they had no opinion on our resolution. And we had slightly more people disagree with the resolution. So they were pro 230 than anti 230. And it looks like right now, most of our live audience has voted, and we have a lot of shift in opinion. A couple people still have no opinion. A few people said that they strongly agree, but the majority of people disagree with our resolution, disagree that Section 230 is harmful, and don't want it to be abolished or changed. So with that, I'd like to thank you all for tuning in, and thank you all for coming.
Thank you for having us.
Thank you.
Thank you.